let's assume what the feds say is true.
We can't.
That they let's assume. Do you know what the word assume means?
Well,
let's
you're leading with your chin on that one.
Okay. Assume the FBI has on tape that they tried to dissuade him at times from doing this violent act. He was bent on doing it, okay? But there was no violent act because they didn't give him access to any weapon. Yet he's charged with wanting to use a weapon of mass destruction. If you're sitting on the jury, all right, putting your pinhead judge title aside, and you hear on the tape that the feds said, you know, maybe you don't want to do this, and the guy is adamant about doing it, do you vote to convict?
I would have to hear the tapes that the FBI did not reveal. I would have to hear his explanation.
So exculpatory evidence, which the defense attorney is entitled to in discovery, correct?
Well, absolutely.
Okay, so you assume you would hear it. Don't dodge. If the tapes show he wanted to kill the people in Pioneer Square, do you vote to convict?
No, because wanting to commit a crime is not the same as committing a crime.
That's not what the Supreme Court said.
We will become East Germany if we prosecute
now you're wandering into
what they want.
Now you're wandering into the land of theory, which you can do on your dopey show, but not here. This is the Supreme Court, okay?
Go ahead. What case? What case?
The Supreme Court ruling on a number of cases using subjective approach to evaluating entrapment. Quote, if the defendant can be shown to have been ready and willing to commit the crime, whenever the opportunity presented itself, the defense of entrapment is unavailing, unquote.
Except when the government has planted the seed, coerced him, encouraged him, and led him by the nose.
You just admitted to me in front of millions of people that even if the government's tape shows he wasn't coerced, he wanted to do it, you still would vote to acquit. I say that's irresponsible.
Well, I would have to hear the evidence of the coercion. If there is evidence of coercion, which I have seen in that same affidavit, this is not the proper role of government. Because if government can do this to him,
you're pulling back on theory again, because we said if it is apparent, and I believe it will be, because I don't think Holder, a very liberal guy, the Attorney General, is going to put his neck on the line, all right, and saying, we didn't, we gave him outs. But you still, and I believe you were telling the truth, you still, because you are a stubborn guy, would vote to acquit the man, even if the tape showed he wanted to kill these people, or a child molester wanted to rape the kid.
Wanting to do evil is not a crime. But it is a thought. We don't punish thoughts in this country.
The Supreme Court has ruled you wrong on it.
Because you read half the quote. The rest of the quote is, if the government planted the seed in his mind, he's not.
If you are on the internet trolling for teenagers, nobody planted.
Don't use me as an example for this.
Okay? Nobody, and if your father calls the FBI saying, my son might kill somebody because he's a jihadist, nobody planted a seed.
Go take 2 years and train him and encourage him to commit the crime.
Now, ladies and gentlemen, there he is, one of the finest legal minds in the country. You decide who had the stronger argument, Judge Napolitano.
I love it, Bill.
Thank you for having me. Everybody does. Next on the rundown, another judge rules that the state of Oklahoma cannot ban Sharia law, even as a 42-year-old Muslim woman files suit because her father won't let her get married. Is it legal? Moments away.